No.
We don't have quorum, we just can't vote.
Sorry. Okay, good morning, and welcome to the Committee on Professional Responsibility and Conduct. As a reminder, this meeting is being recorded. Karen, can you take the roll?
Yes. Ali,
Present.
Brown,
Present.
Coleman,
Present.
Shivers,
Present.
Guzman. Guzman is not present. Kruger. Kruger is not present. Mercado.
Wait, Eleanor should be here. She was trying to get on.
He was at.
Oh, Eleanor. Yeah, I see her. She just popped up.
Present.
Mohebi. Mohebi not present. Munoz. Munoz is not present. O'Reilly.
Here.
Poindexter. Poindexter not present. Riley.
Here.
Thank you.
Okay, next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Do we have anybody?
Those look like we have. So for those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and the State Bar staff will call on you in the order the hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then number 9. We will allow 3 minutes for each speaker. The on-screen will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. I'll go in the order that the hands are received. First, we have Kai. Kai, you have 3 minutes to speak. Kai? Kai, you have 3 minutes to speak.
Good morning. Good morning. Can you hear me?
Yes, we can hear you. Go ahead and start your 3 minutes now.
Okay. Good morning, all committee members. My name is Kai On. Sacramento DA office provide me fake defendant information of the driver who killed my father, Woon Kong On. DA case number 99F08735. Fake defendant, Mr. Jung So Fong. I mailed complaint to Attorney General and Sacramento DA and the California DOJ staff in Judicial Council. I ran into Mr. Robert Bonter 2 times in Sacramento. I went to protest at the front door of Sacramento Superior Court, Sacramento DA office, and Attorney General's office. There's no reason for Sacramento DA, Mr. TNO, and Attorney General, Mr. Robert Bonter, not knowing my complaint. They did not investigate my complaint is obstruction of justice. I filed complaint to State Bar of California, State Bar case number 25-0-12611 and 12612. Attorney General and Sacramento DA refused to investigate law enforcement presenting forgery and fake document and information is a misconduct and is a criminal matter. However, State Bar Office of Chief Trial Counsel claimed that my complaint is a civil matter and dismissed my complaint. As of today, I still don't know who killed my father. Sacramento City even asked a UC Davis internship student to email me a forgery police report. The UC Davis student informed me the forgery police report was reviewed and verified by Sacramento City Attorney Office. It seemed there was a scandal 25 years ago about the investigation of my father's death. Many licensed attorneys in the government are helping to cover up the truth of my father's death and the scandal. I did email the evidence to the committee before this meeting. All committee members, please look into the political power that interfered the complaint process inside State Bar of California and the professional responsibility and conduct inside State Bar of California. Somebody is undermining the justice and legal system of California. Thank you.
Thank you for your public comment. I don't believe we have other public comments.
Okay, thanks, Karen. Now we on to the approval of the May 9th open session minutes. Are there any corrections or modifications to the open session minutes? If there's no corrections or modifications, can I have a motion and a second to approve them? Emil? And
Second.
do I have okay.
Second.
And so we have,
Second.
thanks,
Emil,
Raquel.
sorry, I just want to confirm Emil motioned that and who seconded that?
Raquel.
Okay, thank you.
Okay, Karen, please take the roll.
Okay, I'll take the votes for the minutes.
Yeah.
Ali,
Present. Oh, sorry. Yes.
Brown,
Yes.
Coleman,
Yes.
Guzman, Kruger, Mercado,
Yes.
Mohebi, Munoz, O'Reilly,
Yes.
Poindexter, Riley,
I'm going to abstain given the connectivity issues I had during the last meeting.
Shivers,
Yes.
6 yeses, 1 abstain. The motion carries.
Thank you. Okay, since I don't have a chair report, I'm going to move on to the staff report by Rachel.
Good morning. I did just want to update the committee, the open spots that we have. The process is moving along. The candidates have not been notified yet. And we are waiting on that. And then I did just want to let everybody know that unfortunately Deepika Ravi did put in her resignation. So we will be moving forward with one of our alternates. I wanted to also briefly review the comments that we have received on matters that are currently out for public comment. The first one is 20-0001, lawyer as an expert witness. We extended the deadline at the last COPRAC meeting at the request of the Bar Association of San Francisco. We're still awaiting their feedback. We did receive 2 comments, one from the Orange County Bar Association who indicated that they are opposed to this proposed opinion. They did provide substantive feedback raising specific sections and issues that they believe require further consideration. And then we received a comment from the San Diego Bar Association that would support the opinion if modified. They also provided some substantive feedback in the comments. And the public comment closes for this on August 18th. We also have the proposed changes to Rule 7.3 that are out for public comment. We've received 18 comments thus far. All of them have been in support of the modification, with the exception of one that would support it if modified, and there was one opposition. Many of the commenters did provide substantive written comments. And then I did just want to let the committee know that staff is researching 7.3 in other states. So we will be able to provide some additional information on that. at the next meeting, and public comment for 7.3 closes on July 18th. And then finally, as the committee is aware, the Board of Trustees voted the proposed changes to 8.2 and 8.4 out for public comment at their meeting. And that public comment period ends July 14th. I did just want to note a few things regarding today's agenda. We do still have the work plan on the agenda, just so that we can briefly review the status of the matters, especially the ones that are not discussed substantively on the agenda. And then I did add a new business topic to the agenda, and that will remain on the agenda at every meeting, just to address any issues that we would like to agendize for the next meeting. Because of Bagley-Keene, we won't be able to substantively discuss anything, but at least that provides us a mechanism to bring new issues up so that they can be agendized for the next meeting. And then on today's agenda, we have 3 different requests for new rules and/or opinions. And currently, the only formal process for requesting an ethics opinion is via USPS mail. So if it's amenable to the committee, I would like staff to develop a mechanism for getting these requests in some sort of online form so that we can standardize the process. Everyone answers the same questions, provides us the same information. Just because the way that it is currently working, because the only formal mechanism is mail, we tend to get a lot of emails to the committee. And I think that if we make it a form available online, that will, again, just standardize the process and help us track everything that comes in. And then staff is currently researching UPL and antitrust issues, so I will have an update for that at our next COPRAC meeting. And then finally, our next meeting will be held via Zoom on August 1st. So thank you. I think that's everything I had.
All right, thanks, Rachel. Do we want to talk about just that the standardized process for getting opinion requests? I'm all for it. We don't have to vote on it, right? I mean, is there any objection to that among the people who are here? No? Okay. So I don't know if, I mean, I'm glad that we're going to do that. And I can't believe we don't have that already in place. So thanks for thinking of that. I mean, it'll make your job easier too, huh? Ellen, I'm sorry, I'm looking at your comment, Eleanor. Is it possible oh, it just went away. Eleanor, do you want to say it out loud? Where are you?
Sure. Can you hear me?
Yeah.
Okay. My question is it possible to get staff's research on the various issues you're looking at, 7.3 and UPL, in advance of the next meeting so we can review it before the meeting rather than getting it during the meeting?
Yes, absolutely. That's a great idea.
Thank you.
Okay, so let's move on to the next item on the agenda, the discussion of the work plan. Can we put that up?
I will get that pulled up.
Cassidy, I have a question while we're waiting to pull that up.
Sure.
Well, I'll wait till after.
Okay. Okay. So should we just go down the list? Let me just make sure. All right, so client file release and retention duties 190004. I think, yeah, we were waiting for input from the criminal lawyers about the criminal files. Is that right? Or did we already get that input? And I
Yeah,
think
that was why the committee had reissued it for an additional comment period. We only received 2 comments back. I know for sure that one was from a solo criminal law practitioner, and those were provided to the committee for discussion today, and this one is on the agenda to discuss.
okay, good. Right. Okay, so we'll just discuss that in more detail when we talk about it. Lawyers, expert witness. Hold on.
What are we intending to do with this agenda item? I realize I don't have the context of what are we doing?
We're just going over,
So we're gonna so we're just going over everything like we did last time and adding or subtracting information?
it's just yeah, so if we're not going to do anything substantive, we're just going to get a status of each thing. So, and especially the opinions that we're talking about today, we are, we're not going to, like, I think we had this discussion last time, but we're not going to have the actual discussion about those opinions. We will get to those opinions when, as they are on the agenda. But as to the others, we're just going to get an update, how we're moving on those other items, whether they're
Okay.
opinions or anything else.
Okay, so this is the agenda item is a status update. That's what
Yes.
we're trying to do. Okay, thank you.
Right. Yeah. Just so we're staying on track with everything and we're not losing the universe of stuff we need to be moving forward. Okay. I just wanted to make sure the expert witness one, I mean, because, I think we all kind of forget where we are on some of these things.
On the expert witness one, Rachel, I think you asked whether we should have staff summarize public comment, and I would like to have that happen.
Okay, yeah, I can prepare that for the next meeting after it returns from public comment.
It looks like there's just probably one more coming, the one you mentioned from the BASF, and we can add that and hopefully come back to this for the September meeting.
Okay, flat fees and termination.
No activity since the last meeting. So I don't. So we didn't have a meeting or any kind of communication. So nothing over.
Well, so, okay. Is there any plan for the next meeting?
The chair is not here today, so I'm not sure, right? I'm a member, and so there's been no contact.
Okay. All right, we'll just wait for Brandon to get back. Maybe Emil and Raquel reach out to Brandon and just maybe you guys can have a meeting between now and the next meeting. The next COPRAC meeting, if you can. Okay, conversion clauses. Again, that's okay. We're still revising, and since Brandon's not here, Eleanor, Eleanor, you're on it, Deepika. So this one was she the lead? Eleanor, do you have any
Right.
update on this?
She was.
Sorry.
I can provide an update on this. I think Brandon and I miscommunicated because it was meant to be added to the agenda for a brief touch base. Because he's out, so he asked me if I would cover it, but I thought he submitted it for inclusion in the agenda, but he apparently did not. And I can cover the quick points we were going to discuss, but the issue is that we had a group previously that was very committed to an opinion that took the position that it was per se unethical. I think after lots of conversation, Brandon has been persuaded that it is not per se unethical. I am persuaded that it's not per se unethical. Topeka is now no longer participating. I don't know if she remains on the committee technically at this moment, but we would like to add one additional member to the committee and move this forward. We have a good draft, but we wanted to get general input if possible, if you've got time on the agenda, whether people felt strongly it should be an opinion or if we should go the way of an ethics alert, given that we're not taking a per se position. And the ethics alert or advisory would be something along the lines of, these should be treated with skepticism, they present great risks, etc., and kind of running through some parades of horribles and then, discussing when in, I wouldn't call them narrow circumstances, but when in carefully considered circumstances, they may be ethical and not present problems.
Yeah, I mean, that kind of, and not to get into more substantive stuff, but that does kind of sound like the hotliner that was issued after the ethics opinion on whether or not I think it's 300 now 1.8.1 applies to modification of fee agreements. Because that opinion was just so controversial, and then they ended up issuing an ethics essentially. So we could do that here. But yeah, we can talk about that.
If staff could share the hotliner with me, that would be fantastic. My inclination is to go that route. Brandon's was to issue the opinion. If we add a third, person to the committee, perhaps we can vote it and decide which way to go with it. But I think we're close to getting something out either way. We've got a very solid draft, and we'd like to just make that decision and a few tweaks and then get it before the committee for comment.
Well, if you Google hotliner, or if you, I guess maybe search the State Bar website, you can find that hotliner. And what's interesting about it, I don't know if we want to do this as our procedure, but at least how they did it back in 2008 or 9 was they issued the hotliner and then had all of you can find the hotliner, the opinion that was never issued, and then all of the public comment about it. And so
interesting.
Yeah, so you get the full flavor of the controversy and then how, it ultimately ended up as a hotliner or ethics alert or whatever we're calling them these days.
Well, that
okay.
would be something I'd want to talk about before we issued it, because I think we've definitely covered issues that weren't fully discussed, in the earlier incarnation of the committee. So I'm not sure it's quite as controversial as it was. But that's something that the larger committee could discuss. Yeah.
I don't know. Yeah, I don't know how we want to go about it, but that's what happened in that scenario. So we can, it's maybe an option.
What is the procedure for shifting something from an opinion to an article or alert?
I don't think we have one, right? I mean, I think that's something that we need to, we've sort of talked about it, as criteria is. This is criteria though. We can't come to a decision. We can't come to a consensus about whether an opinion should be issued on a particular issue.
I view the purpose of the opinion kind of more as a admonition to exercise caution, and that in many cases this would fly in the face of the ethics rules, but not on a per se basis. I'm not sure that adds a lot of clarity in many ways. I think we're just repeating the rules. So for me, it would be a good hotliner, but we could produce a hotliner and share the draft opinion and the hotliner for the committee if that sounds appealing, so people could see both and decide whether or not they think the opinion is a better way to go.
Yeah.
I think that is a kind of a good line for something that is a hotliner. And there are many things that in the process of doing the opinion, we determine we aren't seeing a bright line rule or something that would be definitive, which is just sort of context for the existing rules.
Right.
So that seems like a hotliner to me.
Okay. I feel similarly. So why don't we, since I'm probably the last remaining member, why don't I take on the hotliner? And if we can find someone else to, join the group, maybe we don't need it if it's a hotliner. If we decide to go the opinion route, we can add somebody. But for now, I'll take on the hotliner for the next meeting.
Okay.
Okay.
So since she put in her resignation, so she is no longer a committee member. Eleanor, did I just hear you volunteer yourself for lead on this one?
Yes.
Oh, to be the lead? Yeah.
Yes, I will be the lead, so you can replace that there.
Thank
I will-
you.
For the next meeting, you can expect to see a hotliner that we can discuss.
Okay, and this is agendized for today if you needed to discuss it further.
See
We
it,
can.
okay.
But I will make that note here.
I think we've discussed it sufficiently. Unless anybody else wants to add comments, we can cover them later.
Eleanor, I put that link to the hotliner articles on the State Bar site in the chat if you want to see those.
Thank you very much.
Okay. So next one is the ethics of in-house counsel. I think this is on the agenda too, so we don't need to cover it, but we'll talk about it at the agenda. There's let's see. Well, let me look at what we had there. Return after public comment for June meeting, public comment closes. The only thing that I wanted to mention is that we did receive public comment late from PREC, and so that we need we can discuss that when we discuss it at the on the agenda. Okay, cryptocurrency. I don't think there's anything going on with that one, Eleanor.
So I do have a question. I'm on that committee. So I have a question to you, Eleanor. At the last meeting, I understood you to be ready to do something at this meeting, but you just said nothing happened. So maybe just give a status of where you are.
No, it's not on the agenda yet. I haven't done the update there. That's another one that I frankly think is probably good for a hotliner. And the reason, well, why don't I think that's worthy of a more fulsome discussion, and we can put it on the agenda for the next meeting. I'm not ready to discuss it at this meeting.
Okay, so let me just say as a committee member, I feel like we've had a lot of meetings, and I think Eleanor maybe is in a little bit of a different place than Nima and myself. So my thought and how I thought we left it the last time we met, which was probably 2 months ago, was to bring what we have to the committee and get more input. And so I think that's what we need to do. I think we need to get it out of the working group and bring it into the committee to at least have some conversation, because we've not had one conversation on it. Over.
Is there a particular topic you'd like to cover? I think where it stands is that there are some edits that were discussed during our last committee meeting that have not been incorporated, and then it would be reviewed and then shared with the broader committee. And I've not done the edits.
You asked me a question and then you started speaking. Can you repeat your question?
Yeah, was there a particular topic that you want to bring before the full committee, or do you want to follow the process we discussed in the last call, which was to incorporate the edits, which have not yet been done?
So
and bring it to the committee.
Well, what I'm saying is in the next meeting, we need to bring whatever we have to the committee.
Got it.
Because we haven't brought anything to the committee and we're just working. And some of the things that I have understood to be your issue were not Nima and my issue. And so what we said was, let's bring it to the committee and at least start getting input, because we're working in a vacuum with just 3 of us and it's supposed to be representative of everyone. So we weren't trying to get it to be perfect.
Yeah, I didn't share your
So
views
that's
on
the
that,
so that's what I'd like to do. I don't have my topic is the opinion topic. So it's it's just to begin to talk about it, as we talked about. You know, even is it cryptocurrency now? Because this has been is an opinion that started probably 4 or 5 years ago. And so we've been talking about the broadening it.
Cryptocurrency.
Right, that's what I'm saying.
The decision was to
it.
narrow it back down, and that those edits have not been done yet. Correct. They're in my court.
Well, I didn't think, so that's the point. We didn't say it wouldn't be digital assets. Again, I think that's where you are. And
No, I
you
think
happen to
Nima
be.
and and you all agreed on.
Nevertheless, point, I think this is a demonstration. We need to bring it to the committee and just start having to have some dialogue about it. So that's what I
Okay.
like. That's what I'd like us to do. And if you don't get the edits done, then I think we need to present what we have.
I
Because
have no objection to that.
thank you.
Did you say over? Like
I did, so she knows I'm done speaking, right? So you don't talk over each other.
It's like a CB. We're good. Okay, ethics of in-house counsel. This is the conflicts, former client conflicts. I think Emil, you guys were, and Carrie, you guys are the only two on the working group that are here. Is there any progress on this one, or do we need to kick it to the July meeting?
So I think we do need to kick it to the July meeting, but I can give you a short update. Carrie spent a lot of time so I think everyone was having trouble with the flow of the way we had already redrafted it. So we had a draft that was provided to us. We redrafted it, and I think we just wanted to change it up a little bit. So Carrie took the lead to redraft it, and now we're just kind of figuring out how to fill in the blanks together. We were hoping to get it on the agenda this meeting, but hopefully next meeting or the meeting after that. I think a lot of us have just been busy with other things, but we have a lot of good changes. I think it's going to obviously need to get sent out at some point, but I think we can definitely still get to the goal of Q2 2026, if not earlier, to get it out for public comment.
Okay, good. All right, so we'll have that on the July agenda, hopefully. Okay, attorney adjacent work and handling retainer fees. We do have that is on the agenda today. There is an outline that frankly I prepared a long time ago, so it'll be just a brief kind of status, because what we'll need to do is just turn the outline into an opinion. No, there is an outline, yeah.
There we go.
Okay, so that we can cover that on the opinion. Can you get, I'm sorry, my husband's calling me and I don't know why. Can you guys, can I take a quick break? I don't know if I have an emergency right now.
Sure.
Sorry about that.
Maybe someone can mute Cassidy, because I think she forgot to mute.
Did you stop recording?
It's still recording.
Alarm. Okay. Okay, where were we? I'm sorry. We were on the outline for the adjacent work, and that we'll talk about that a little later. And then here we've got, is this the arbitration advisory?
Yeah, this one's complete.
Okay. Yeah, this one's complete too, right? We've done this. Yeah, that's just, you just reported on that. Okay, and that's complete. Okay, these are all. And so are we at the, so you can, I think we're at the agenda item where you wanted to talk, where we're going to talk about the symposium. Are we done with the work? Oh, the
This is the last thing on the work plan.
sorry, different things. Oh, so this, yeah. Okay. So this is kind of what we're talking about. How do we determine between an alert and opinion, and selecting new topics? I mean, do we need a working group on this? I'm just asking for everybody's input. I mean, I think the work plan works very well, with, just keeping everything managed and, on our radar. I'm just wondering if there's do we really need more processes is my
Well,
question.
I have a question. I think that Rachel mentioned there are more requests for opinions. Do those just go in to the queue and then we determine those once a year with the work plan, or are we considering those on a rolling basis?
You mean, so just, yeah, so maybe that's what we can try to figure out. But so Rachel, we've got, you get the request for opinions. And then, we've got like the hotline staff who made us that we'll talk about. So requests for opinions come from various different sources. And then I remember we did used to have just the chart of all of the lists of opinion requests. So Dan, are you asking, like, should we continue to go over that, or should we have that as part of this and periodically go over it, and how often, that sort of thing?
Yeah, I think the
Yeah.
question, like it's a procedural question. Do we do the work plan once a year and then it's fixed, or do we kind of do it on a rolling basis?
The opinion requests, you mean go over the list of
Adding
opinions
something to this
requested?
work plan. Yeah.
Yeah. Well, I'll open that up to, I mean, and I don't think we need a working group to come up with that determination. I think we can just talk about it with the committee, but it might be, I mean, I would think that maybe it's something we do on a quarterly basis,
Right.
go over the opinion requests.
I like that.
Does anybody have any thought about that?
If I could just interrupt really quickly, the purpose of this group was to determine which articles, what format would be taken, like the criteria for opinions, hotliners, as well as addressing what how you're going to select new topics, the time frame for that, and determining what an average timeline should be for opinions. So I think that the intent behind this was that the working group was going to grapple with these things and make suggestions to the committee as whole, as opposed to the committee kind of grappling with all these ideas. I think that that was just the intent of the working group, just to kind of level set for everybody.
Okay.
That's the way I understood it as well. And I do think, I mean, the purpose of a work plan is to say, this is the work that we're going to do between this time. And so unless there's some extenuating circumstance, we shouldn't really be adding things until we complete things we have. Otherwise, you are
Well, no, I mean,
I haven't said over yet, Cassidy. Otherwise, you run the risk of getting where we came out of, which is why the work plan is, is an important tool, which is you have a lot of things on your list and you don't complete them, but you're always taking on new things. And also a framework as a group to decide what things we would take if we take it. Because for a lot of times we've been taking things to say, I'm interested in this topic, or I think this is important, or X, Y, and Z. And how does that fit with what is at the beginning of this work plan, which is the framework in which we're making choices. So to me, that's this what I understood this last working group to be working on, is to create a framework to make those decisions in a way that is less personal and more related to COPRAC, and more structural, a more structural way to do it, so that if Cassidy's not here, meaning when we have a new chair, we're still working under the same rubric. So that's my understanding, and I'm over.
Yeah, I appreciate that. And I appreciate Kathy's point that, you know, coming up with a structure for opinions and the distinction between opinions and alerts and how we're going to make those decisions. My only thought, and not necessarily concern, is that it's hard enough for us to be, you know, moving things along without, you know, more processes that we have to follow and more, you know, so I don't want to, yeah, I mean, that was my only thought, is that, you know, sometimes committee work, there's too much procedure and not enough substance. And I like the work plan that keeps us on task, but I don't think we should have just so much, you know, processes that we have to follow that gets in the way of the work, the substantive work. So that's my only thought. But how about this? We've got, I'm here, Eleanor, Dan, the three of us should probably have a meeting and discuss what this looks like and have it presented for the next meeting.
Yeah, I think it's worth doing. I think it could be also relatively short, but like guidelines for some of
Right.
these topics, and you know, setting up more objective standards for other people to think about something that would rise to the level of an opinion to present that option, or a hotliner. And it could be 2 or 3 pages, but at least it's objective, that everyone,
Yeah.
you know, we can present it and people can then give their thoughts, and we would approve something that would be a framework for bringing stuff through.
Okay. Okay. So we'll do that. And we'll come up with something that's not onerous and is helpful and productive. Okay, so that was the last thing on the work plan.
Cassidy, can I ask a quick question? So
Yep.
this goes along with the question about, I think it was Dan's question about how we're going to determine, you know, which new submissions to look at, et cetera. But is there a possibility that we're going to have a high influx of submissions? I'm not saying we should not make it easy, but should we, not that I want to have a process, but should we have a process to like, hey, within 60 days of getting something, we're going to try to adjudicate it. So we'll send it out to the group, come prepared to spend, you know, an hour voting on whether we're going to do something, just so that it just doesn't sit in a queue.
You mean like opinion requests? I mean, the chart on, we haven't looked at it in a while, but the chart on opinion requests is like pages and pages long, but it goes back, you know, several, I don't know how many years. So I don't know, maybe Rachel, you can speak to this. I don't know like what the influx is of opinion requests, but I would think that staff could cull them and put, you know, the ones that are, you know, I mean, that are reasonable for us to consider. And then we can have a process for, you know, making determinations whether or not we're going to, you know, tackle them or make them an opinion, make them an alert, you know, and discuss them at the meetings. And that's what our working group can talk about.
Sure. And it's very possible that there might be a large influx of new requests. And I think that's the point, is like, maybe we should have a plan. And maybe that's the suggestion, is for that working group to come up with a plan that says, hey, let's adjudicate these. Or so maybe staff can help divide them, but then we should vote on, we are not going to be looking at these because they've been determined to not be relevant or not be authorized by our committee, but these ones we will put on a list, just so that when people see, hey, I submitted something, at least they can see that it was looked at, reviewed, and adjudicated.
Yeah, do we want to do, I mean, that's a question. I mean, you know, are we going to publicly address every single request that comes in? I don't know if that's the intention, because that would be probably and take up a lot of our time. I don't know. Maybe we just need to see what, maybe when Rachel sets up the process for submitting new requests, that we'll see what the influx is. I don't know. Rachel, do you have any idea of what is the volume that comes in on opinion requests?
I don't.
She's in.
I've been here 2 months now, and we have 3 today, and those are the first 3 that I have received.
Oh. Okay, so these are all the discussion of new ethics opinion agenda item, those are all the 3 requests. So in other words, would you have, if there were like 10, would you have put them on the agenda? You know what I mean? Like, or did, okay.
Yeah, as of right now, putting them all on the agenda as we receive them. And it just so happens that there were none last meeting, there are 3 this meeting.
I see. Okay. So that's kind of a new process that we haven't done before, but we'll talk about that during our working group, and maybe Rachel, we're going to want your input. Because I want to know, because that's not how, I mean, where's Dan? That's not how we handled new requests in the past.
No, I think
It was just,
we have publicly considered them in the meetings, which are obviously public, but it's been more
Yeah.
ad hoc, maybe a couple times a year. We went back and did
Yeah.
that. But it can be more formal. I think quarterly would be great. And if there's nothing, then we're done. Move on from there.
Yeah, no, I have no problem addressing, new opinion requests, if there's 3, if there's 10, we can go through them. But, I just want to make sure it's not like our entire meeting and we're not like bogged down. So I just want to make sure that, we do have a process in place for that. So,
I mean, the question also
okay.
for the working group would be whether the working group should take the first pass at and then make a recommendation. So it's like an intake working group, basically.
Yeah, so I think that's, or the staff could do it. I guess
Yeah.
it just depends on, our working group will just be the first step in talking about that process and whether or not we're going to take on we're going to create a working group for intake, or staff should do it, among other things. So, okay. I think that's a good idea.
Are you proposing a working group to study whether we should have a working group? Let's do that.
Exactly. I know. See, this is what I'm talking about.
We're going to streamline it. The working group going to collapse.
So I started out with, I don't want too many processes, and now I've got, working groups on top of working groups. But no, I think, to be serious, I think that, we should come up with a process, an objective process on the, considering new ethics opinions.
Yeah, and I will just
Okay.
add that, that in, COPRAC coming into line with work through these things, because when we do have the formal work plan next year, we will have to decide how we're going to handle the requests for opinions and stuff. So I think you could easily come up with a process that the person submits the request and it's addressed at the, before at the next COPRAC meeting or something of that, or within the next 2, something like that. I think we could easily work, but just in terms of thinking about coming in line with the other and the requirements that COPRAC is going to have next year, I do think it would be a good idea just for us to kind of grapple with these things now, so that we're not caught flat-footed with, 100 requests for opinions.
Yeah, I mean, yeah, it's just, we just don't have a good feel of what the volume is. So whether it should be quarterly, whether it should be every meeting, whether it should be, it should be a huge cut through a first pass by staff or a working group. Those are all kinds of things that we can figure out now as opposed to next year. Okay, anything else on that topic? No. Okay. Do we have on that working group? Sorry, it's me, Dan. I'm sorry, I don't have the. Do we have enough people on the working group? Is my question, because I don't see. I don't have it in front of me anymore.
I think there's 5.
Me, Dan, and Ellen.
Good.
Okay, I think we're good.
Mercado, Mojave, Poindexter, O'Reilly.
Oh,
5.
okay, so we're good. Okay. All right, we will, between now and August 1st, we will meet and come up with a plan. Okay, so next item is the symposium presented by Rachel.
Yes, So all of the feedback forms that we received were circulated to the committee members, so hopefully everybody had a chance to review those. This was agendized at the request of the committee at the last meeting so that we could debrief on this year's symposium, and then if there's anything that we wanted to note to make improvements for next year's, we can go ahead and do that.
Okay, so I mean, do we have any suggestions for improvements or any other comments about the symposium? No.
I did have some numerical questions, I guess, to you, Rachel. For context, how many people were registered? How many people actually attended? How many people got the credits? Those kinds of things. I'm interested.
I don't have the stats pulled for that today, but those are good questions and I can get them to the committee.
Okay. So, and then I had a question of, I had a question I didn't understand. For example, it says there was 185 responses in 198 results. What does that mean? Like it was next to each question. That one happens to be the first question for the first panel. And I just didn't understand what that means.
Let me pull up the document so I can see exactly what it is you're looking at.
Does someone else understand what that meant?
Oh, I see what I'm going to share my screen so everyone can see. I see what you're talking about. Okay, so this thing down here.
Yes, yes. What does that mean?
I don't know what that means. Karen, do you?
I do.
They're not required to answer the questions.
Right, yes, so maybe 198 people answered it, but only 185 responded to this particular question.
Okay, so let me then understand how this was done. So I thought these were done after each segment, but was this survey done at the end of the symposium?
I have to double check that. Give me 1 second.
Because I think if I was understanding you, if they did it at the end of the survey, end of the session, then I'd understand that answer. But I thought these were being given out for each one. But I didn't receive one, so I don't know. But okay.
They were being given out after each individual panel.
Right.
But obviously it's up to the participant to decide what questions they want to answer. And then I'm sure we had attendees that didn't even click on it. So, their responses wouldn't be captured.
Okay, so 198 people were given the survey for panel 1, but only in the first one, it was only 185 responded. The second one, only 184 of the people who received it.
I think the 198 is the number of people that took the survey total, and then the 185 answered that particular question.
Okay.
Everyone that was attending the panel would have received it.
Okay, I understand. Thank you.
And let me just provide a bit more context. There were 828 people who registered for the symposium.
Okay.
667 attended. So that's consistent with about the 200 people per session. The link to the survey was provided at the end of each panel and the follow-up email with the MCLE certificate. So that's how it works. So it would have been panel per panel.
Okay. And Kathy, since you have the numbers, do you have the number of the people who got the credits? No,
it doesn't look like we
you
broke
don't
it
track
down.
that?
It doesn't
Okay.
look like we broke it down between how many attorney and non-attorney attendees. But let me check.
Oh, my question is about the credit, and I guess let me say the context, because the reason we're doing this symposium is to not only be educational, but for people to get the credit. So I was trying to, and there's a criteria that seemed like you had to be there for the whole time, you had to be on your computer, so there was some criteria that knocked some people out possibly. So I'm thinking that the registration numbers and the credits is the quantitative assessment that goes with, did people like the information? So that's why I'm asking. I
Okay.
think those are like, we should know that.
Yes, I agree. Let me just double check to make sure that we are tracking that. And if we're not tracking that, we can make sure that we track that for next year. But let me double check, okay?
Okay, I mean, I don't necessarily speak for the committee, I'm just saying my part. So I wouldn't automatically say track it if the committee doesn't want to track it, but that's I'm just giving you my logic on why I'm asking, why I was asking those questions. I think the only thing I would say, I thought the questions were effective. I did think that the question that asked about time for the panelist was not appropriate because the panelists were not managing the clock. So for example, the judge. So there's a question that said the speaker effectively managed the time, but the judge didn't really have anything to do with the time, as the facilitator. Or in my AI panel, they said that, that was a question for the panelist as well as Nima and myself who were facilitating. So that was the only question related to that I saw that didn't really jive with the, I don't think we should measure that because I don't think they had anything to do with that.
Raquel, just some context for some of these things. I think if you claim MCLA credit, it's self-policed, meaning there's nothing in the system that would tell whether you're actively watching it or not. You have to do that yourself as an attorney. Two, on the time management, I think that is the number one complaint that people have about CLEs, that there's a bunch of material that was in the materials and never covered. So it's more of a note for future facilitators that whatever you're putting in the materials should be covered, because people get very frustrated when it isn't.
So appreciate that, Dan. So I thought what I was saying about the credit for the person is not whether there was this, and several people mentioned it, and I thought it said when you went out, you couldn't look at it on your phone, right? So you had to be at your computer.
Yeah, but you can walk away or take a call or do different.
Yeah. But I'm just saying that if you, there's some people may not have done that. So that's why I said about that. And my point about the speaker is just the panelists are not managing the time, right? So we're giving a question that doesn't relate to the role that person was on. So we have skewed data. If we're saying, oh, we want to be data focused, we have data that's skewed because we're asking a question that is not related to what that person did.
Well, not necessarily. I mean, the whole panel is responsible for covering the materials that, that are part of the presentation. So
well, the question I'm talking about is only about time. It's not about what was covered. It was, did the speaker manage the time effectively? It didn't
but that's
say.
what, sorry.
You're assuming, I guess, that meant they because most of the concerns seem to be, which I can see that as well, is that people didn't get their questions answered. So it was much more one-way talking. So that's how I relate with managing the time, was that you got to the end and people didn't have questions.
That's one component, but I think another one is there was a bunch of materials in the written materials that weren't covered.
Okay, so so I didn't see people complain. Well, I saw people saying they couldn't see the material until after it was over. I did see that, which I think is an issue.
I do
as
agree
well.
that yeah, I mean, I do agree that the question, and I think we may have talked about this before or at some point, but fielding questions and answering them and having enough time and space to deal with them should be better for next time. It is very difficult, and we did get a lot of questions. I think every panel did, and it was really hard to address them all. So I don't know what the answer to that is because you can't just answer questions for the entire period, you know. But so I think that's something that we can put on, you know, the list of how to improve the symposium, you know, and that is a time management issue for sure.
Okay, I have a little bit more info. Ms. Coleman, if you want to go first, I do have a little bit more information for the committee, but I do see that your hand has been up.
Oh, sorry, and I don't have the faces. I'm sorry. Go ahead.
Okay, thanks. On the managing questions, I think sometimes people will use like in Zoom the upvote feature so that if people because I feel like it's hard to always answer everyone's question, so they use like a consolidation process just so at least some of them are answered. But also I think having like, if there's more than one facilitator, like having one of them do internal sorting and just like do it that way. Cause I agree that it's hard to achieve the balance of having everyone's questions answered. And then for the written materials, I hear the frustration of like, oh, this was in the written materials and you didn't talk about it. But sometimes I like when I go to an MCLE and the written materials are comprehensive and I can like pull them at a later date and use that as a resource. So I wouldn't want us to be like stingy on our written materials just because we think we're not going to talk about it all during the presentation.
I agree. I think that's a good point. It's more of a basis for frustration when people think it's going to be discussed, but it could be presented in the written materials as like supplemental or additional materials, you know, that won't be discussed. It could be followed up on individually. That's a great idea.
Yeah.
Okay, let me give.
And you know.
Oh, go ahead. Sorry.
Yeah, no, I'm sorry. I forgot. No, go ahead, Kathy.
I just wanted to give you some information about the MCLE certificates. For panel 1, we issued 399 certificates. Panel 2, we issued 393. Panel 3, we did 347. And panel 4 was 333. So you're seeing about a response of about half of the people for those surveys. But those were what the numbers look like. And I think you make a great point, Raquel, about asking the question if the facilitator managed the time effectively as opposed to maybe the speakers. And in terms of kind of dealing with some of these questions and just the best way to kind of facilitate these panels, a staff would be happy to work with the symposium panelists next year in advance just to make sure we have some of those issues covered because we do have a lot of ways that we can manage that. And I think that some of them were indicated here, like you can create an outline and then indicate that the written materials have much more extensive information about that. You can have 2 facilitators, one specifically for the questions, one specifically to keep time. So there's definitely ways that I think that we can deal with those things and really help the committee bring the best symposium possible to our licensees.
Is the notion of an in-person symposium now completely off the table? Do we ever want to revisit that? I mean, I think there's pros and cons, obviously, but you know, the whole idea of question and answer is so much easier with an in-person and more robust. And I think we all kind of like in-person. Well, personally, I like in-person CLEs better than remote, but of course we get a bigger audience with the remote CLEs.
I think we could explore that option. I wouldn't be optimistic, because no.
I know.
And I mean, and I think the reality is that we have gotten so many more attendees going virtual. And
I mean, we could, well, can we do both? You know, like it could be available virtually, you know, I don't know.
like a
Not that-
hybrid.
Yeah. Anyway, so I'm just throwing that out there and just questioning whether like it's just a done deal or we can still explore it. And we don't need to obviously make a decision right now. Okay.
But
So
the-
anything else on this? Oh, go ahead, Dan.
Just a quick note. I mean, these are really good thoughts that are worth coming back to as we develop the next symposium, not just about the topics, but about this is like the nuts and bolts of how it's presented, which is really helpful. And it's a good idea to think about these as we go to the next one so that we can have a staff spotting questions or whatever we need to do to properly manage this stuff.
Should we, in kind of along those same lines, should we include, I kind of felt like symposium planning was put on the agenda too late, you know, I think, or I feel like we should have been discussing it maybe a little bit more earlier. And then I don't know, I mean, maybe that's just me. I feel like we didn't have as much time to discuss these particular issues. So maybe we can put symposium planning earlier in the on the agenda earlier in the year, so that we can talk about this a little bit more.
I think it makes sense. I also think it makes sense to invite the speakers earlier so that you're on the calendars. I'm getting messages for some panels that are happening a year out, and I think it's helpful.
Oh yeah, I know. I'm like, well, I mean, usually I'm like, really, next February? I mean, you know, but yeah, I mean, it's, yeah, so, and that doesn't necessarily mean we have to plan the whole thing, but I do like the idea of maybe, you know, next meeting or the meeting after that, talking about structure, you know, at least, and throwing out topics and that sort of thing. So, just a thought. Okay, anything else on the symposium? No. Okay, so moving on to item 411, discussion of new ethics opinions and rule requests. And this is what we were talking about earlier about the new ethics opinions that Rachel received. And so there were three. One, request to update Arbitration Advisory 1999-02, request to adopt rules regarding attorney use of AI, and then a third, request to issue ethics opinions on ethical obligations when an attorney makes a mistake. And so just briefly go over those three. The Arbitration Advisory 1999, it's I think that it's a good idea to have an update because it has to do with ADA accommodations for arbitration, fee arbitration attendance. So those parties that are, you know, that are in a wheelchair or have, you know, some kind of disability covered by the ADA. And obviously now I think, well, I don't know if all of them, but most fee arbitrations are done via Zoom. And this clearly doesn't cover any of that. So I think there certainly is a need to update that. And Rachel, do you have any further input or insight into that request?
Yes, this came from Arbitrator Stone, who was attending the meeting earlier. Yes, and he's still on. He did indicate that he is available if the committee had any questions or needed additional information. And just for the committee's information, I did look into that, and according to the Board of Trustees handbook on committees, it is up to the chair's discretion to allow a member of the public to speak specifically on an agenda item that is separate and apart from public comment. A public commenter cannot double dip and speak both at the beginning and on the agenda item, but that is to the chair's discretion. So if the committee had any specific questions, he is available.
Oh, okay, yeah, I mean, to the extent we do have questions, I'd be happy to hear from Judge Stone. I mean, my main question is what specifically does he envision being updated other than, you know, what I can assume to be just you know, the evolution of how arbitrations are being handled these days.
Yeah, when I received the request, it referenced the fact that this is, yeah, from 1998, and a lot of the accommodations that are referenced in this I don't think are really being used anymore. So I think it's an issue of updating it to reflect the current state of technology.
Right, right. Okay, so it seems pretty straightforward. Is there any, sorry, I thought I heard somebody.
Novella has her hand up.
Oh, okay. I can't see, I don't have my. Novella, go ahead, sorry.
Thanks. I thought this one was interesting because it's framed as the duties. I know because it's probably because it's the ABA it's framed, or is this the California State Bar? California State Bar. So it's framed as the duties under the ADA, and there's recent California and federal, well, there's recent federal case law that shows a split of authority on whether the ADA applies to public accommodations that don't have like a physical space and that are limited to a virtual space. So I think if the arbitrations are happening via Zoom, then it's not helpful to talk about duties under the ADA when for the federal case law, there's a split as to whether you would have any duties. And then to the extent that we want to say like these are duties for California, I think it would be helpful to talk about California law that doesn't make that distinction. And so the UNRU Act, there is a published decision that says it incorporates the federal definition of business establishment. So that could potentially result in the same problem, but there's other California laws besides the UNRU Act that addresses accommodations. So I think if we did something on this, it would be helpful to consider duties under California law and not just limit it to the ADA.
Okay, thank you. I was just gonna say we maybe need some volunteers for our working group to update this, and I would nominate Novella, who knows, who seems to know more about this than at least I do. So any other comments or insights about this? And I think, do we need to vote? Because I do think this is plainly shouldn't be updated. So what's the process? Do we need to vote on whether or not we're going to do that, Rachel?
Yes, the committee can vote on it, but before we get to that, I just wanted to note that Arbitrator Stone does have his hand raised, as does Raquel.
Okay.
Sorry, I'm having
No,
issues.
that's okay. Thank you for calling that out.
Popping out.
No, so Arbitrator Stone, I'm not, I need to figure out my screen here. So go ahead, please, provide some insight.
Karen, are you able to?
Yeah,
Thank
yeah.
you.
He should be able to talk now.
I should be unmuted at this time. Is that correct?
Yes.
Yes.
Okay. This is Clark Stone. I'm the presiding arbitrator for the State Bar's MFA program, and I'm just appearing on behalf of the program in place of staff. I did ask that this arbitration advisory be updated to be more current with the way arbitrations are handled. The vast majority of them do occur via Zoom, and also we assign arbitrators to these hearings, to these panels now statewide. So, but that said, many local bar associations also include the option for in-person hearings. So the advisory would actually need to provide advice to bar associations that do in-person hearings, and also those accommodate the Zoom hearings, which are the majority of arbitrations that are conducted now. We do get requests. I wouldn't say they're fairly regular, but typically they're in the context of someone attempting to avoid a hearing by raising at the last minute a request for an accommodation, typically with the Zoom hearings to not appear by video or to appear in person. So I think it would also be useful if the advisory includes advice for the program or for the arbitrators in scheduling a hearing to affirmatively explore the need for a reasonable accommodation with the parties at some time before the hearing is actually set and scheduled. I think that would help avoid some of these abuses that we have seen. I do believe the tools we have can address most requests for a reasonable accommodation, even with a Zoom hearing. Things like written submissions, having an attorney appear, telephonic appearances for those who claim to need an accommodation with respect to using video. But so I think that the tools do exist, but I think the advisory needs to be refreshed in a way that makes it more current with the way we're handling arbitration hearings statewide now. And that said, I'm happy to answer any questions.
What's the, I know that a lot of local bar associations are no longer doing fee arbitrations. I mean, is that true? Is there, because a lot of them, what's the percentage, if you know, of the breakdown between local bar associations versus the state bar doing, conducting the fee arbitrations?
I don't know the exact number, but I think currently we're down from about 24, 25 local bar associations down to about 18.
Okay.
The vast majority of the ones that have dropped out have been in Northern California, Contra Costa, Bassif, I believe up Napa and the like. So the state bar staff can tell you, but their workload has increased pretty dramatically because the state bar obviously has to pick up that slack.
Okay. I don't have any other questions. Oh, go ahead.
And I
Sorry.
will note that that's the reason for the rules being changed to make Zoom hearings the default, and also to allow for statewide assignment of arbitrators to local fee arbitration. It used to be we tried to take into account, assign someone from a local bar when the state bar assumed jurisdiction, but that's really not possible anymore given the increase in the workload.
Okay. I don't have any other questions. Does anybody else have any other questions for Arbitrator Stone?
I do. Just if you can clarify, what are the accommodations that people are asking for, and or I thought I heard you say something that made it seem as though what they're asking for is not legitimate. So I'm just trying to understand what are examples of either of those?
Well,
Of
for
the-
example, we'll get requests for a reasonable accommodation being an in-person hearing instead of
Okay.
a video conference hearing, and you know, supported by some claim of having difficulty with processing information in a virtual environment or something like that. There are other accommodations, but that's the most recent ones that we've encountered, and usually those sort of requests are made at some belated time in the proceeding, typically right before the hearing has already been scheduled, and in some cases, an in-person hearing just simply isn't feasible given where the arbitrators are physically located on a panel throughout the state.
Thank you.
We have had, we typically will make accommodations for interpreters or language barriers. I don't really believe that's considered a disability, but the rules do provide for people to have someone helping them interpret or translate, and it doesn't have to be a certified translator or interpreter. It can be a family member, and other accommodations can be if someone's not able to participate electronically. They have the option of submitting on the papers or having someone else present their case. Those are sort of, they kind of walk the area between a disability related accommodation and just being able to participate accommodation.
And right now, that's at the discretion of the arbitrator. All
Well,
of those decisions.
Many of them are a change from the default of a Zoom hearing, which is our default, requires my approval, but as far as attendance at the hearing of someone to help with a language barrier of some type or a learning disability, that would be handled typically by the panel chair or the solo arbitrator for that particular.
Thank you. No further questions.
Okay. Okay. Any other questions? Can we vote on putting this on the list of, it's not new opinions, but an updated, to update this arbitration advisory?
I think we need the committee's work on how we're going to do that, Cassidy.
Well, that's
from the
what
working group.
What do you mean?
Well, you're.
What do you add?
So I don't think we should vote to add because we don't have a process to say that we are going to be taking new things to add. And I think that's, this is an example. And I will say 2 meetings ago, we did add something and I just didn't say anything at the time, which was the nonviolent, the domestic violence one. But I think,
well, we
can vote, but I think this is an example, right? And then why we need to have a process of.
Well, you can vote against, right? But you can vote against not adding it. You can vote against not adding it to our list of things. And if we all vote not to add it because we've got too many things to do, then that's what it is. But I think we should take a vote as to whether or not we're going to add it to our list of tasks to take on.
I understand that, because my point was, you were saying, do we need to do that work in the work plan? And I think this is an example of, we don't have a process, so we just always are adding things. And either we vote it up or we vote it down, and we all have different reasons why we're doing it. Over.
Right, but let's just keep as we're coming up with a new process, let's keep the committee work going. And if we think we've got too much on our plate, then vote no. If you think we can do this, take this on right now, with, maybe an extended deadlines and that sort of thing, we'll put it on our work plan, then vote yes. I mean, that's, at this point, I think that's where we're at. So do we have a motion to add this, to update this arbitration advisory?
Novella
I'll
has
move to update it. Sorry. Go ahead.
Do you have a second?
Second.
Okay. Can you call the roll, Karen?
Yes. One moment. Okay. Ali? Brown?
Yes, sorry. Sorry, yes, I was just.
Okay. Ali, yes. Brown?
No.
Coleman?
Yes.
Guzman? Kruger? Mercado?
Yes.
Muhebi? Munoz? O'Reilly?
Yes.
Poindexter, Riley,
Yes.
Shivers.
Yes.
So that's 6 yeses, 1 no. The motion does not carry.
Sorry, that's carry.
What? How did it not carry?
Yes,
Oh,
the motion should carry.
yeah. I did.
So when
If-
we are, I'm just looking at the COPRAC rules. And when the committee is determining whether or not to issue a formal opinion, it may determine to proceed when a majority of the voting members of the committee, not just a majority of those present at the meeting, determine that the request set forth, and then it goes on.
So if I change my vote to yes, would it go forward? Because I'm able to
Yes,
change my,
because
okay,
7 would be a majority of the committee as a whole, and that is what we need in order for it to move forward.
okay, I'm fine to say yes.
Just to clarify, the rule you're reading, thanks, Raquel. To clarify, the rule that you're reading seems to relate to issuing a formal opinion. And
Right.
this
an
is
update.
about drafting. So I think this is an informal process if my recollection is correct. And I think the chair has in some cases decided what would be drafted in the past. So I'm not sure that the rule is as strict as it's being read by staff right now, but could we clarify that for the next meeting?
Yeah, we can, and obviously I'm new to this, so I'm
Yeah.
learning it as I go. Yes, and I can look into that and clarify it for the next meeting.
Rachel,
Thank you.
can you also circulate those rules?
Yeah, I can put the.
Or is there a
link-
place online we could find them? I'm just curious. I don't think I've ever seen them before.
Okay, so
Yeah, that might be a good starting point for getting to know the processes, right?
That is a good start.
Yeah.
Okay,
And
so I
I-
just want to put on record that it is 7 yeses, so the motion will carry.
Yeah, okay, fine.
Okay. And so,
And
do we,
I'll volunteer to be on the committee. It's fine.
okay. So do we have volunteers for the working group to begin the update drafts?
I'll volunteer.
Thanks, Novella. And so we have Novella, Raquel. Do we need, is that sufficient? Do you guys think you can handle it? Do you want to, can we have one more?
I'm not on another committee, so I feel like I probably have more capacity than everybody else. So I feel like we're good.
Okay, well, let's see where you're at the next meeting, and then if you want another person to the working group, we can address it then.
I do have one clarification question. So the opinion right now seems like it's a like what does the ADA mean question. So I was wondering in terms of just like COPRAC and what we're interpreting, this seems different in that it's not interpreting a like rule of professional conduct. And having not been around in 1998 when they did this, I was wondering if there's like any guidelines for like when an opinion is construing like another source of law, or is it like better to find some sort of hook in the ethics rules before going down like this is what the ADA requires, going down that path?
I mean, I don't think we've ever been strictly tied to just ethics rules in terms of our opinions, but this is also an arbitration advisory, so it even kind of takes it out of, the traditional ethics opinion as well, because this is intended to be guidance for arbitrators in conducting fee arbitrations for the most part. So I don't think that I think you can focus on those rules, but what doesn't everybody else think? I don't think it needs to be a treatise on, the ADA and the UNRRA Act and that sort of thing. It just needs to be practical guidance. Is that sound correct, Rachel and anybody else? Yes, okay.
Yeah,
So
I
just,
think that makes sense.
okay.
So I heard
Use
it,
your best judgment is kind of what
yeah,
my,
I,
given
I,
those given that, those parameters. Go ahead, Raquel.
I heard it in some way to be a, a bit of a different order. It almost as Judge Stone said, putting the idea that Zoom is the default. So
For the state bar arbitration. So, you know,
which is
arbitrators,
different. And now from a legal matter, I don't have any idea if there's an issue with that, but it sounds like that would be like, how do I get forced to have that as a default?
why don't,
So but that's how I heard the purpose in some way of updating it, is because it's done in a different era. And so
Can-
therefore virtual, and so it doesn't even have to be Zoom, just virtual is not part of the story, but it's the current operating practice.
why don't we have, if Arbitrator Stone is willing to have him be a resource to the working group about, you know, just all of these details, that would need to be part of this update. Is he still listening?
I think I'm still unmuted, and yes, I'm happy to provide any assistance, and I can also I'll also commit to the state bar staff I work with in fee arbitration, helping also, because they're not here and they can't say no.
Okay. Okay, so Novella, and Raquel, why don't you guys come up, you know, all those questions, direct them to Arbitrator Stone, and then you can come up with a good universe of updates that could be provided, that could be applied to this advisory. Okay. Next one is a request to adopt rules regarding attorney use of AI. Right. I don't think there was anything in the materials on that, although
There wasn't, because this was one that
Just a
someone
request.
had just reached out to me directly. And the request is, this person is submitting a formal request to the committee to propose to regulate the use of artificial intelligence among members of the state bar. I would propose a rule that would subject California licensed lawyers to state bar discipline for allowing official communications, filings, etc., which incorporate AI work product in such a manner that reproduce AI hallucinations that cite non-existent authorities and/or legal evidence that should be properly vetted by the lawyer before they use AI in this manner. I would also propose adding a rule that defines unauthorized practice of law to include AI work product that is disseminated by a non-attorney for the purpose of asserting legal claims and arguments on behalf of a third party. And then the last request as part of this was, finally, I recommend that the state bar also forward similar recommendations for changes to rules governing state judges subject to the Commission on Judicial Performance.
Wait, repeat that. What was that again?
The last one was a recommendation to change rules governing state judges. So that piece at least is not
related to AI?
Not under the purview of COPRAC. It looks like they would like to apply their prior recommendations, not only have them apply to attorneys, but apply to judges as well.
I see. So my only thought, I mean, those are all good, you know, issues that should be addressed. The only question I think we've grappled with before on this is that because the technology is ever evolving and things change, that it's hard to, you know, capture capture it in a rule. And that's why we put out the guidance last year or 2 years ago, the AI guidance, which I think can be not easily, but can be updated without it having to go through the Board of Trustees approval process, I believe. So those are my only thoughts. But beyond that, I think that yeah, those are all important issues that all state bars should be addressing. I think Angela has her hand up. No.
Novella.
Novella?
Oh, is that Novella?
Yeah,
Why does it say Angela?
I
Go
thought
ahead.
the guidance is still effective and relevant, and that, so I guess given I've used it recently and it still works, and I think it's still true that like at least the examples that were just read aloud are already prohibited by the rules of professional conduct. So I would push back on the need for like a rule or a ethics opinion, because I think it's pretty clear from the guidance how all of that works.
Yeah, I mean, I think, right. I mean, that's kind of, what I think we could do is have something where we periodically go back to the guidance to determine whether or not there have been new issues popping up or new things that require us to update it. But yeah, I mean, I haven't looked at it in a while, and if those issues that Rachel just raised are covered by the guidance, I mean, the guidance is pretty broad in terms of, because it's supposed to kind of move with the times. Then yeah, I mean, I think we've addressed those issues through the guidance. Does anybody think that we need an ethics opinion on AI?
Or rule changes?
No.
Or rule changes, but yeah, I think rule changes are I think we already addressed that, and I think that what we did, we thought the guidance was the more appropriate vehicle for addressing AI. But an opinion, is just sort of like a belt and suspenders, and anyway.
Don't attorneys have duty of competence?
Yeah.
Is that one of your duties, right? So that all of what she read follows under duty of competence.
Yeah, absolutely. I mean, and those are all, well-covered territory. I think the point of the requester is that we need to have a more specific, acknowledgement about the use of AI, because it is going to become, and it is prevalent. So if there's no rule, but you're right. I mean, it does fall under your duty of competence. I mean, of course, you can't cite cases that you don't, you haven't bothered to check exist or not,
And say, oh, it was the AI. It wasn't me, it was the AI. No.
I mean, and there's judicial decisions that are covering this, and you're getting sanctioned for, so there's all kinds of other guidance out there that, lawyers should be aware of just as part of their duty of competence. So,
I don't see the need for a rule change at this point. I based on conversations we had in the working group and with outside experts, I think it could happen that we would see the need for a rule change and new rules might need to be developed. But right now, I think all the issues we covered in the guidance are still the relevant issues. People talked about, autonomous decision-making and delegating work to AI agents and whether or not they would be authorized to practice in certain areas of law, et cetera, but that I think is well beyond our scope right now. So
I do like the idea. I mean, I don't think the guidance addresses this, but the UPL component of it, just the non-lawyer, what is AI, and so I don't know if when we begin to address UPL, what are we doing with UPL? Wait, Rachel, there's a request. The Board of Trustees is addressing whether or not we can address UPL, or are we allowed to address UPL yet?
We are allowed to address UPL, and actually, now that you mention it, I think that was, I think we maybe had talked last meeting about potentially getting a working group together on or adding this as part of the working group on how to address UPL issues, because we may need to go through a slightly different process because of the antitrust issues. But like I mentioned in the staff report, we're still doing research on it, and we'll get that to the committee.
that could just be an update to the existing guidance, though, once we're
Right.
address it.
Yeah, because I'm a little fuzzy on like where does it all fit in within like the, you know, a lawyer's obligation not to commit UPL. You know, I mean, really, it's more just non-lawyers who are, you know, using AI to practice law, but that's not really, doesn't really fall within our purview. Okay. Okay, so we don't need to take a vote on this, right? Are we all just in agreement, going to move forward with an opinion or rule change on AI?
So we
Right.
are or not?
Not moving forward at this juncture. We can always revisit it. But I do think we should, you know, make sure we're periodically reviewing the guidance to just make sure that we're capturing any new issues that pop up. Okay, and the last one is request to issue an ethics opinion on ethical obligations when an attorney makes a mistake. And I think this came from hotline staff from the state bar hotline, ethics hotline.
Yes, that is correct. I attached the article that kind of prompted this idea and this request.
Yeah, sorry, go ahead, Rachel, go ahead.
Yeah, no problem. Here, I can at least share the cover page so you know what I'm talking about. And when I was talking to hotline staff about this issue in particular, they indicated that there weren't a lot of it's not a high call volume in terms of the number of attorneys calling in asking what to do when they make a mistake, but the concern was raised that perhaps they are too afraid to call the hotline, and so it might be a good idea to have some sort of written guidance on what to do when an attorney makes a mistake.
Yeah, I mean, I do risk management consultations all the time. And this is probably 50% of my consultations. It's what do I do when I make a mistake? And you know, there is, well, first I want to ask, where is this article? I mean, I see who wrote the article, but how did this come to be in the possession of state bar? Like, is this something they're relying on, or is this something that they just found? And, you know, what is this? It's a good article, but
I mean,
just curious where it came from.
He's published this on, like, he just wrote a blog post about it last month. He's trying to publish it, but he's at the Mercer University in Georgia, and he's a good guy. He actually does a lot of stuff in the IP ethics field as well.
Oh, okay. Is he in April? I've actually never heard of him.
Not a member of APRL, no.
Okay. Yeah, no, it's a good, I'm glad you brought this to my attention. It's helpful in my, you know, with what I do. But there are, you know, and they're right, there's the ABA opinion on this, you know, how to recognize a mistake, and what to, you know, whether or not you have a duty to communicate the fact of the mistake to a former client versus a current client. And there's no California COPRAC opinion on it. There is the opinion about settling a malpractice claim with a current client, and and it's cited in this article, but there's a you know, a part of that opinion that talks about the duty of disclosure of a mistake, I believe. But one of the you know, and so I do think whether or not we vote it out and do it now or at some point, I do think this is a really important topic, basic, fundamental topic for an ethics opinion, because, you know, a lot of times what I get is, how do I know this is a mistake? You know, because a lot of things are judgment calls, and it's oftentimes, you know, a lawyer has to consider whether or not, you know, considering their own malpractice, which, you know, there's whole malpractice lawsuits about whether or not malpractice occurred. So, you know, lawyers have to consider whether or not, you know, what they did is an error. I mean, there's easy ones like missing a statute, or, you know, missing a deadline, and like disclosing experts or something like that. Those are, you know, clear errors, but there's this gray area that could be covered in an opinion. And then there's a whole other part of it that has to do with the conflict, whether or not the mistake creates a material limitation conflict with the client. And so that could be another component of the opinion. So anyway, I'm all for an opinion at some point in the fairly near future. And I'm happy to be on a working group on this because I deal with this all the time. Any other thoughts, comments, Novella?
Yeah, I thought this article was super helpful. At first I was like, I thought there was a California State Bar opinion on attorney mistakes, but I think it's just called something else and discusses attorney mistakes. So formal opinion 2019-197 does like analyze some of the principles that overlap with the article that was in the agenda items.
Is that, let me see.
So that is what ethical obligations arise when lawyers in a law firm consult with outside counsel regarding the representation of a client.
Yeah, that's more of the privilege issue one, right? Where you're
a little bit of conflicts, yeah.
Yeah.
I mean, if you don't mind, maybe I'll kind of give a couple thoughts about this. This is a very, Cassidy, in your practice, in my practice, mistakes, whether it's a potential ethics issue or, conflict issue, or, hey, I forgot to file something, or I put the wrong provision in a contract, blah, blah, blah. But I cite to the ABA opinion all the time, and it's clear. I think I'm open to seeing one, but do we really need one interpreting California rules? I don't know, because I feel like it may end up muddying the water more because there might be positions being taken, which I don't know. I worry about that just because we have a clear, short way of saying if it's a current client and they're a reasonable attorney standard would say you did something bad, you got to let them know. It's a former client, then you don't need to know. So then or don't need to let them know. So the analysis is the reasonable attorney standard. Like, would a reasonable attorney think that it was a problem, or would a client think it's such a big deal that they would terminate the representation? And that's the way that I look at it. Very simple, to the point. Do we need to add more to that?
Yeah, no, I agree. I mean, that is a good point, but and I want to go back and look at the ABA opinion, but what I am envisioning is more examples, of what that really looks like, because I think attorneys struggle with that, and I struggle with it when I'm giving this advice, like really trying to recognize whether or not something is a mistake, whether or not it's a judgment call thing, whether or not, and so I'm not, I would say, I want to go back and like really look at the ABA opinion, and that might be the starting point to have a working group, at least, I don't know, working group, but somebody go back and look at the ABA opinion and say, can this be, expanded on? Is there something more? Is there something missing here? Because, and I don't know, I think there's value of having a COPRAC opinion. There's definitely opinions that the ABA has issued that we have issued on the, very similar grounds and topics. Just because the ABA has an opinion out there doesn't mean that we can't issue one too. Any other thoughts? No. Okay, well, how about this? I will take a look at the ABA opinion. I don't think we need a working group, but I want to kind of look at it a little bit more closely. I think Emil has a good point there. But I just think that it's such a common thing that I'm hesitant to just, say that, oh, we don't need an opinion on this. It's a common issue that affects all lawyers, no matter if their practice area or anything. So I'll take a look at it, and maybe I will bug Emil about it too. And the next meeting, we can talk about it a little bit further. Okay.
I was also gonna flag, there's a San Francisco Bar Association has a blog post on this topic called Legal Ethics and Attorney Mistakes, written by Carl Chamberlain, and that's helpful too.
Yeah, I mean, there's no doubt there's a lot of information out there on this topic. But I mean, we're COPRAC. Maybe we should be addressing it, with our authority. I mean, not to put in quotes, but with our guidance. Okay, Raquel, you have your hand up.
Just, should we not just vote on it to take an action since we voted on the other one?
Should we, I mean, I don't, do we have to vote on just kind of informal exploration?
I don't
Is
think so.
that the subject? Yeah.
Let me just add at this point something for everybody to take a look at, a homework assignment. Rachel put our rules into the text. There's a link to them. I think we should all look at those because number 6 has responding to opinion requests. And it's something that we should start internalizing. It doesn't prohibit this, but it does address this. So the working group that comes up with the rules will start there.
Oh, rules. Okay. So it's the one that says rules. I thought you said roles. I'm like, I don't see that, but it's the one.
Yes.
It says rules. Okay.
From Rachel. At
From
11.
Rachel. Okay.
Is there a way, can you circulate those, Rachel, too? I mean,
Yes, I can email it out
Okay.
to the committee so everyone has a link, including people that weren't able to attend.
Okay.
okay.
Maybe
you.
Rachel, can you put all the links that are here? Like Dan put the hotline or if you just send all the ones, that'd be helpful.
And
Yep.
if I could ask one more thing, I think the SharePoint site has not been updated. I might be the only person that actually uses it, but I tend to look for things there. Maybe we can kind of put something with all the links there. I don't want to create more work, but if possible, yeah.
I support that. It's more effective for me too to look in one place with everything.
Emil, are you trying to access the agenda materials?
Right now I've been using the link that the Granicus whatever link, the PrimeGov link. But yeah, in general, like if I'm looking for historical information about an opinion, I usually go to the SharePoint.
Okay. Just because I'm not sure if it's just the materials, they have been posted on the COPRAC library.
Mhm.
But the historical material I would have to follow up with Rachel.
When you say the library, I think that was Karen. What you mean? What do you mean? In our SharePoint?
Yeah, it should be there. I updated for this meeting. It's on the SharePoint, so it's the COPRAC library. It should be under agendas.
Mhm.
So at the top, if you go to the SharePoint, there's the file name agendas, and then it'll redirect your page to another page where the folders are titled by the agenda dates or the meeting dates.
Karen,
So yeah,
perhaps you could share your screen just to illustrate what you're doing so that they can see maybe.
yeah, sure.
And I do see it. I think last meeting I couldn't see it, but it looks like you guys updated it after that. So yeah, thank you.
Yeah, I could quickly show you guys that you guys know how to access this. So if you just
I thought it was last meeting too, so I didn't go. I asked the question before I checked. This time I saw it was there.
Okay, if you guys do need me to share this, I'll share the link with you guys. But for those that don't know, this is the COPRAC meeting homepage, agendas, all the material we posted here on the folder, and it'll be titled under the meeting date. So I'll share that with you guys right now.
So yeah, you could even put in put on a page all these links in whatever this meeting is, June, and then we could access it.
Okay.
Yeah. I copied them, but just in case something.
Can you add it to the Zoom chat? And then I'm just gonna save the chat and email all of the links out after the meeting. Thank you.
Okay, anything else on this? Okay, next item is the legislative advocacy, presented by Rachel and Emil.
Yes, so it is noon. I'm happy to keep going. I just wanted to check in on time. But yes, I did conduct some research, and committees are not able to comment on legislation without approval of the Board of Trustees. And if a committee does comment on any pending legislation, it would be on behalf of the state bar as a whole. The rules indicate that the committees do not comment or advocate on their own behalf. And again, we would need permission from Board of Trustees to do so. So I don't know how we want to move forward, but that's kind of the authority and the constraints that we're operating under.
Okay, I'll just note that to that specific bill, the state bar has provided comments. And I guess my question was, who provided comments? You know, how is staff of the state bar making those comments on behalf of the entire organization? You know, has it gone through the Board of Trustees? You know, are they soliciting feedback from committees before submitting that feedback? So, because I saw some of that, the proposal, like the proposed changes made by the state bar, and I was very surprised by them.
So I can respond to that.
Surprised not in a good way, or
Uh,
surprised positively?
No, and not in a good way. So,
Yeah, I can respond to that. So we do have a legislative office that reviews all legislation that might impact the state bar's operations. And then the office leaders review the statutes, and then we provide feedback that way. So that one specifically was reviewed by, it was kind of a crossover because Erica was still the director of the Office of Professional Competence at the time. And so that was how the comments were provided to our legislative director, who then reaches back out to the legislative staff.
I see. Okay.
But there's not necessarily a solicitation from committees in terms of what the responses should be.
I see. Okay. Not that I want to add extra stuff to our plate, but might be helpful. Obviously, it's too late for something like this, but there's something else that impacts, you know, for example, how attorneys are regulated. If the legislature wants to create, you know, a new, because, for example, the attorney-client relationship in California is very unique because it's also in the Business and Professions Code. They want to make an edit to the Business and Professions Code that impacts lawyers. I think it would be helpful to get some input from COPRAC before, you know, because whether it's the board or COPRAC, there are attorney members that might have some input outside of the normal talk to your legislature like process.
I can definitely provide that feedback to our legislative staff as well.
Thank you.
Okay, anything on this topic? No. And then new business. I don't have any new business other than what we've kind of talked about already. Rachel, is there anything I should be addressing for the new business item?
No, this is just kind of our standing new business topic that if anyone has any requests, either from committee members or from the public, just so that we know to agendize it for the next meeting.
Right.
This is what you
Okay,
I don't have anything.
This is
Okay.
This is what you talked about earlier, Rachel, like that you had to do this to, yeah, okay.
Yeah. Yep.
Yeah, so but everything that's like on, I mean, maybe I want a clarification. Everything that's like on the work plan and everything that we've already discussed, obviously none of that is new business. This is like truly something totally new that we want to have on the next agenda. So raise it now, right? Is that kind of the point here? Okay. So I don't have any new business. Does anybody have anything they want to put on the agenda for next time to discuss? Yeah, no, okay. So just keep this in mind, you know, because I did I'm sure this maybe we'll have more of this at the next meeting, but have this before the next meeting so that if you want to raise topics, you have that in mind for the next meeting, and that we can discuss it during this new business item. Okay, we have a lunch break here, but I don't think we have much else to talk about unless the other items that were not on the agenda, we are going to discuss any of them. What do you guys think? Rachel, what do you think? I can go through the opinion, the in-house counsel opinion very quickly. And then the other one was the outline on the adjacent, attorney adjacent work that we don't really even have on the agenda, but those are the only two things I have left. That would be pretty quick.
I will leave it up to the committee. We, I think, we've definitely lost quorum for now because Carrie had to jump off. And then I know that Raquel, I believe, has to jump off during lunch. So I'm not sure if we will be able to get quorum again. So we won't be able to vote on anything, but we absolutely can discuss things.
Yeah, so my proposal on the in-house counsel opinion, my thought was we would be able to vote it out, but because we got the letter from PREC, the LA County Bar Association, basically opposing the opinion, and we only got that earlier this week, I believe, or late last week. And because Brandon's not here and I kind of want to talk to him about it, I propose that we table that opinion until next, table voting it out or whatever, until next time, because I want to consider their letter a little bit more closely. Did anybody read? I'm sorry, I'm just moving on. Are you guys okay with that? Because I don't have anything that I would like to vote out or put out to vote out. Is there anybody who wants to address anything else, or do you guys want to take a lunch break and come back, or do you want to just go through?
I'd rather just go through. I don't think we have a ton left.
Okay. So, and my next question is anybody opposed? Speak now or forever hold your peace. Okay. My next question is did anybody read the PREC public comment letter and have any insight comments about it? Basically, they oppose our conclusion on the in-house counsel opinion that Rule 1.8.1 should not apply, or our conclusion that it does apply to the ownership of stock options for in-house lawyers and their employers, the companies that they work for. And so essentially that was their opposition to our conclusion that there's this per se rule there. And we've grappled with this for I don't know how long. That was our original conclusion, and because of public comment saying the opposite, we revisited it. So I'm open to revisiting it again based on this letter, but I just haven't had a chance to digest it. Novella?
Yeah, I guess one of my questions was trying to understand if they were opposing the conclusion because they want a carve out that under no circumstance would the rule be implicated when the stock option is written into the attorney's compensation, or if it was they wanted like a more nuanced fact pattern so that like under some circumstances it could be and under others not. And I wasn't sure how much of it turned on like that distinction between focusing on the ownership interest words in the rule versus the later part, which I think qualifies all of the other ones about like the adverse, that it's not just an ownership, whatever, or other adverse interests, but understanding that like in some circumstances, it would be more likely to be adverse and then others not.
Dan, did you have?
Yeah, I did read the letter and go through it, and I think it's just a restatement of what we've been grappling with from the beginning. And to Novella's point, it struck me that they don't have authority for the position that it doesn't apply. We
Right.
do not have a carve out. That's what we've been sort of grappling with from the beginning, and I think Emil added a good modification in the last draft that captured this. The facts in there are pretty nuanced, I think, or to illustrate the types of scenarios where you would have to deal with these issues. It's not really how people do it, and it's not welcome, but that's the reason we're doing this.
Well, and I think, I don't know if it was explicit or if I'm reading between the lines, but I think they would prefer that we just not issue the opinion at all, because it's just basically, the way things are, the status quo should just, remain. And then it'll disrupt, and it's basically what we've been grappling with. Okay, if we issue opinion to say that this rule applies, across the board, then it's going to be an uproar with all these in-house lawyers that hadn't complied up until now, but we can't, that's not a reason to say, that's not a reason to just ignore the issue,
Yeah, and I think the opinion covers scenarios where it probably wouldn't be an issue. And, pretty clearly, and issues where it's something that you should think about very clearly. By the way, we're talking about disclosure here.
Right.
It's not that difficult to comply, and you are a licensed person. You need to comply with all the rules.
Well, and I think when we talked about this with Nima, because we wanted to get more insight about like what is the practical reality here, and the practical reality is, well, if you go back and look at these agreements, they do comply because there is, it's usually there is independent counsel already, and it is, of course, not of course, but it's fair and reasonable because the employer is the one who's proposing the terms, so it's not as concerning in reality as they're making it out to be, but. So,
well, in practice, it appears to be a divergence from what people are thinking, but it's not clear why they're thinking the rules don't apply.
Right. Right. Exactly.
We directly have considered that there is no authority for the fact that these are exempt from that rule.
Right. And it's funny because the letter basically says there's no authority for saying that it does apply. Well,
if you're a licensed person, all rules apply, right?
Right. Right. That's what I kind of found curious about the letter, which is, they took such great pains to say, well, there was a lack of authority cited in the opinion, and the authority is the rule. And what we said is there's no authority for an exception, so that's why we came to the conclusion.
We couldn't find one. We certainly looked for one. We looked for even authorities to suggest that there were different distinctions we weren't drawing here. It's just a category of the rules that people have decided not to think about.
Right. Exactly. But still, okay, so I appreciate this discussion. I do want Brandon to be part of it. So I don't suggest we vote it out, especially since we have so many committee members missing. The other main public comment was from Orange County Bar and from the BASF, San Francisco Bar Association, and it was really more about just dealing with that footnote where we addressed the distinction between the ethics rule and the civil liability arising from a failure to comply with the rule. And I can't remember, we actually didn't have a final revision to the footnote, Rachel. I think I proposed language to Dan and to Nima, and then I don't think I actually sent the language to you to put it in there. So that still needs to be done too. But basically the working group agreed with those opinions to just basically take out that footnote or limited it to just saying that we're not addressing the civil liability, that it's beyond the scope of the opinion. So that's kind of the non-controversial public comment that I didn't have a problem with.
I think it's worth putting to the next meetings. I would like to hear from Brandon whether there's more context for the concerns, particularly with regard to whether there's concern that in practice this would be difficult to comply with or would capture a lot of things. Because I think it wouldn't, and I think most of what people are already doing is probably compliant. But if if they feel differently, that would be good to know.
Yeah, and we can, as the working group, I forgot that Brendan's on our working group too. As the working group, we can talk amongst ourselves and then do more of a presentation at the next meeting. Okay, so anything else on that opinion? Nope. And then we did talk about the client. Eleanor, you talked about the client file and retention when we talked about the work plan, right? Or Eleanor's not, she's gone. And then the only other thing is the attorney adjacent work handling retainer fees and the outline. I think it was maybe part of the materials, but I think I wrote the outline a while ago. I haven't fleshed out much beyond that, but it is slated to be turned into an opinion. So I think the working group will just continue working on that. Did you guys have an opportunity to review the outline? If you haven't, we'll just deal with it at the next meeting. Or if you had any comments on it. No? Okay. So
I did review it. I felt like I think I understood the direction you were going, which is the expert is not the personal attorney, so therefore the rule didn't apply. That was kind of how I read what your draft said. Is that correct? Is that?
Yeah. Yeah, but one of the things that Vikita's not here, but one of the things she pointed out that I thought was valuable was that, and she's on the working group, is that, we should address whether or not you should put funds in the trust account as a protection measure,
Right.
And so, but then that gets into questions of can you, and I think that's part of the outline, is, if you are putting those advance fees into the trust account, is it commingling, so to be candid, I need to think about it more closely and we need to actually start working on it because it's such an old outline.
So I did have a question. That's a good reminder of what she said. So my question is, what's the protection for the client, if you will, for non-performance? So in other words,
You mean the expert?
The expert. I pay you a deposit. What's my non-performance protection? Meaning if you don't show up, you don't do what you're supposed to do.
Well, if you don't do the work.
Yeah.
So let's say the case settles and you have you have basically a retainer in your trust account, or you accept a retainer, you don't put it in your trust account, and and you're expected to testify, to review stuff, and then the attorney calls you and says, hey, the case settled, and great, if the money's spent,
right,
and it's in a trust account, not in a trust account, then the attorney who hired you is not protected. I mean, of course, if you're an attorney expert, you have, I don't know. You have a
Shouldn't
fiduciary duty
that-
not to do that, but
Right.
so you know, it's so do other lawyers who have money in a trust account.
So
who
that was
take-
the only thing I saw, is that if it's not in the trust account and it gets mingled somewhere else, you have less non-performance. You may have a non-performance issue.
Yeah, I think it's a non-performance issue. That's it. Yeah. So beyond that, I mean, you know, I guess there could be if there's a dispute, you know, and you're, you know, and under normal circumstances, you would have to hold the disputed funds in your trust account. So, you know, all of those rules could apply equally in the expert context. And the question is, you know, is it deserving of protection in this context? You know, any different than a client, attorney-client, traditional attorney-client relationship. So so I think those were the issues that Vikita raised, and it's something that, you know, we should address in the opinion, which is, should we be recommending to that it as a, you know, recommending, even if it's not required, it should be recommended as a matter of client protection, and the client being the attorney that hires you, or it could be the party that hires you, I guess. So anything else on that topic?
I'll just note that the issues that Cassidy, you just indicated that Vikita raised are definitely of interest to the state bar, and specifically the Division of Regulation, because we do get a lot of questions and inquiries from attorneys related to CTAP compliance and where do they need to be putting these funds. You know, especially when we're talking about things exactly like this opinion is kind of envisioning, you know, attorney adjacent work and handling that, and the overlap with CTAP compliance. And so that's definitely something that our licensee base has a lot of questions about, and that regulation gets a lot of questions about. So I think it's, yeah, I think it's great that the opinion is going to be addressing some of those issues.
So I've been the attorney adjacent work question. I mean, I've been just focused on expert work, but there's, I mean, you know, there are certain law related services that, you know, you have to go through that analysis of whether or not the law related services is subject to the rules, right? Is that what we're talking about too? You know, or are we just talking about expert work? I mean, what, you know, what, like, I don't know, like an accountant. Well, what's an example of a law-related service provided by a lawyer? You know, lobbying, or yeah. Go ahead, Emil.
Yeah, like a lot of folks do compliance services
Right.
that they try to consider non-legal. But yeah, so, you know, that's where Rule 5.6 comes in a lot in other jurisdictions.
Right. So and we have and I don't have it off the top of my head, but we have the ethics opinions on that question, and, you know, whether or not there's the 5.6 analysis on that. So my question is, do we need to go through that whole analysis as part of this opinion, or are we just dealing with the trust accounting issues? Because I'm trying to think of like what law related services has this issue where you're getting a retainer, and, you know, funds that you don't know whether or not to put it into a trust account.
I get in law related businesses, we get the questions of the trust accounting. The expert thing is to me a separate, unique category, because there's some authority for the position that it's not the practice of law, as we've talked about. But then in the other law related businesses, the question is, just because I'm a licensed person, do I need to comply with all the rules in this context or not? And if a non-licensed person wouldn't have to, why do I?
Right.
Where's that line?
Yeah, but the line, I mean, so there is that analysis of that line. And so if the rules apply to you, then yeah, well, then, but usually there's a client involved, you know, right? I mean, usually.
Yeah, I mean, right. But if I go out and open a dry cleaner, obviously I'm not following the rules of professional conduct doing that. So if it's not the practice of law, why should I be worried about the rules?
All right. I just need, okay, so I think I'm gonna add to the outline about, something other than an expert and how that comes into play in terms of trust accounting. Yeah. I don't know. I think, I think it's worth addressing other than, going beyond the expert role. Okay.
My dry cleaner doesn't require a fee deposit, so that's not an issue.
Can you restate the principle that you're concerned about there?
Who?
Yeah, so to me,
Yes.
when a lawyer runs a law-related business that is not the practice of law, where's the line about the application of the rules of professional conduct?
And if you look at ABA, look at the model rule 5. We don't have a 5.6, right? Is it 5.6?
Yes, sorry, it was
No,
5.7.
it's
I misstated it. 5.7.
5.7. Is it 5.7? Yeah. And it talks about that distinction. Like you have to go through the analysis of whether or not the law-related services has to comply with the rules. I mean, you always have to comply with the
Lying and
what's
stealing.
the lying and cheating and fraud stuff. What's the why am I blanking on the word?
Dishonesty, fraud, deceit, misrepresentation. Yeah.
Yeah. Well, you have to comply with 8.4 and all that. But this is, do all the other the conflicts rules and all the other rules apply to this adjacent legal service that you're providing. And so a lot of
An
times
open question because we don't have 5.7. So we counsel people, that's the best we have, but it's not directly applicable.
There are a few ethics opinions on it, like the is it like the insurance broker or the tax? But it's usually a situation where you're acting as an attorney or you're providing a service to a client, like you're providing legal and non-legal services to a client. So you have an attorney-client relationship established. It's just, are you providing them non-legal services in conjunction with the legal services? And so, you can have a situation where you're like, I had a situation where I'm trying to think where the attorney was providing just like therapeutic services for family law clients, something like that. But charging separate, having two different engagement letters for both. And so if you get a retainer for the legal services, that obviously goes into your trust account. But what if there's a retainer for the non-legal services? Does that also go into the trust account? And you would have to say yes if it's, you determine that all of the services have to comply with the ethics rules. I think that's the analysis.
Yeah.
But it's
if you're a lawyer running a coffee shop, you're not going to put the money for the coffee in a trust account when they place the order and, move it over when you give them their coffee. That's not a law related service. Similarly, if you are a real estate agent that has a California state bar license, you're not expected to have a conflict waiver for your, business transaction with the client because you're getting a commission, unless you also have a law practice where that person's a client. So I think so it would be great if we had 5.7 just to make it a little bit clearer. So if we were going down a path to say that we needed to talk about this in an opinion, I would say, why not just adopt 5.7 if that's something we can do, make a recommendation for that.
Right. So we probably should first figure out why that didn't happen.
Yeah.
Which I don't happen to know off the top of my head, but I think it would be a circumstance like the real estate broker, like the tax advisor, who does something as a lawyer that non-lawyers do. And when they're doing it, where's the line, the 5.7 line in California, which doesn't have 5.7?
But it kind of follows it.
Yeah.
Which is based on ethics opinions. Yeah. Okay.
But that's still news to a lot of California lawyers. 5.7 is not well known.
Yeah, I would be curious to go, I mean, right, I mean, I would be curious to go back and find out why 5.7 wasn't adopted, because like, what is it, I mean, we know why some of them weren't adopted, like was at 1.13 with the one about the capacity, the client capacity, had to do with our heightened confidentiality rule. I don't know why 5.7 wasn't adopted at all. Like, I can't even think of a reason.
I think the working group can go and try to find that, and because they did issue comments when they adopted or not adopted certain things. There were only a couple that didn't make it through.
Yeah. Um, okay, so there's this whole kind of like fuzzy area of the 5.7, beyond the expert type work. Because then it just comes back to the trust accounting. Like, what do you do with a retainer?
Also, just to Emil's point, there are coffee shop and dry cleaning are obvious examples, but there are a lot of examples of true questions about what is a law-related
Right.
business? How close is this to practicing law? How are you defining that exactly?
Yeah, that's what I'm saying is like that's the issue is that when you are, because that and just because we've got so many lawyers who are entrepreneurs now and who are providing those types of services, that it's a real issue, you know. Okay, so we'll go back and keep developing the outline and opinion. I don't think we'll have an opinion by the next meeting, but I think we can talk about these issues in more detail or just give a status update. I mean, it's probably more realistic to have a draft opinion in like the fall. It's probably what I'm thinking. Okay, anything else on the agenda or anything else that you guys want to discuss that is on the agenda?
Just on this same topic, I know that one of the questions that regulation gets asked frequently is in regards to district attorneys who are holding funds, whether it's like victim restitution funds or some sort of other funds related to the case. Does that have to go into a client trust account? And I can follow up with regulation and see if there are any other particular kind of attorney adjacent fees or things that they are getting questions about, so that those can be specifically, hopefully, addressed.
Yeah, that would be really helpful because the district attorney thing is like completely not on my radar. I would have not have thought of that at all. So, that's something that,
How does
well, if you
I don't
can,
even know off top, like from that, how does a district attorney come into possession of client funds?
yeah.
Yeah, I don't know. I never did that type of work either. So I'll
Something
go
we
to
have to
regulation
explore.
and I'll get the get additional information and pass it on to the committee for consideration.
Yeah, but it would be
Okay.
good. Any other categories, like you said, would be very helpful.
Yeah,
Because then we can narrow it down too. Novella?
yeah, to the district attorney list, I would also add not just any district attorney, but also like civil prosecutors, whether locally or for the state of California, might end up recovering damages or restitution for aggrieved individuals for whatever law they enforce.
Well, how do they handle those funds now? Do we know?
Sometimes it goes directly to the person, and then sometimes the like defendant pays to the government prosecutor's office, and then they distribute it to the people who were identified as those who would recover.
Because wouldn't the government then have to have some sort of trust account? I mean, I think it's just sort of seems odd that we would require prosecutors to open up a private bank trust account. I mean, wouldn't it all be part of the government handling of those funds?
I mean, I think I without knowing much about the topic, I think that the question is, they have funds for others, they receive money, holding it for another person, it to be held in trust. But why do we have that? That's so that one, the attorney doesn't steal it, and two, it can't be used or taken away in a bankruptcy or some third party can't take it away. I don't I mean, while we've seen counties and all that, like Orange County go through bankruptcy, I doubt that's going to happen. And I feel like that's just a kind of a waste to force them to do that. I mean, there's always the risk that, you know, not a prosecutor themselves, but the office could take that money and say, well, we're not giving it. I mean, they could decide to do that, but then somebody could go to court and force that. So I don't know if I mean, I think we should review what comes up and decide what to do, but I'm not sure if that's something that needs to be done.
Right. Well, yeah, we could review whether or not what our protections are in place, or, you know, like by the county or the state or whatever, for handling those funds. Yeah, because I just don't know. So yeah, so a list of, you know, scenarios or types of engagements would fall under these types of adjacent work that we want to cover in this opinion. Okay. Anything else? Nope. Anything else, Rachel, before we adjourn?
Nothing for me.
All right, so I think we are adjourned. Thank you all, and you guys have your homework. All right, thanks you guys.
See
Bye.
you next time.